now. And I know that Chairman Willard, Representative Lindsay are still in judiciary. Expect him. The first thing we need to do is approve the committee rules. These are the same ones that we've had, just updated, of course, regarding the rule numbers. Let y'all. That'd be great. Thank you. Move second. Any discussion? All in favor? Aye. Thank you so much. How's your schedule, Chairman Hill?
You're my last.
Okay. Madam Leader, you want to chair while I present? Thank you. Thank you.
The first time in my life I get to say this, the chair recognizes Chairman Wilkinson.
Yeah, we need you. In your folders, you will find the substitute that we're going to offer to HB 310. It's LC 286605 ERS. Madam Chair and members of the committee, this is a technical correction or corrections that have been requested by the Commission. We've taken them verbatim, and I think they make a great deal of sense and will certainly make it, I think, make the job a little bit easier for the Commission and the staff. And I would like for Ms. LaBerge to go into the detail, if that's okay.
Certainly.
Good afternoon. This bill, I can either go through it section by section real quickly. If you want to stop me, just feel free. The first section was put in because the House Bill 142 and 143, the Speaker's bills, actually it's 143, takes the qualifying fee away as not being counted as a contribution. And in order for that to not be counted as a contribution, you cannot count a qualifying fee as an expenditure. Otherwise, you're never going to balance on your reports. So the first two sections here take qualifying, the language, the last line of each paragraph, takes the qualifying fee away from not, it's no longer considered a contribution and it's no longer considered an expenditure. The reason it was done in 143 is because of the breakdown of if you do not spend or receive over $2,500, they're not going to have to report at the local level, and so they're taking the qualifying fee out of calculating that $2,500. So this would just bring the statute, it would put it on par so that we don't have an expenditure on one side and no offsetting contribution. The next change is under Section 18, and it's under the ordinary necessary expenses that are explicitly listed in the code section. There has been quite a bit of angst over attorney's fees. There was a fairly high-profile case that the Commission resolved last summer, and one of the key points was the attorney's fees. There was an advisory opinion that the Commission did, and basically what this does is add attorney's fees as an ordinary necessary expense, but only if the fees are connected to and in the furtherance of the campaign. So you would have to be able to prove that the attorney's fees were directly campaign related in order for them to be considered an ordinary necessary expense for a candidate. The next change is down on Section 22, line E. This is where it lists those people that have to file the affidavit if they're on the board.
Can you refer to the page?
I'm sorry, I'm still on page 2, almost at the about 2/3 of the way down. It's Code Section 21533, number 22, and then it's E.
Thank you.
It's adding counsel to the list. Currently, boards, commission, and authority members have to file the affidavit. There have been some members of councils that claim they don't have to file because it doesn't explicitly say council. So this would just bring them into the fold of those entities that are required to file the affidavit. This is in lieu of the personal financial disclosure. It's not for elected officials, it's just those people that are members of boards, commissions, and authorities. This just adds councils to that list. I think the next change, I apologize, I should have marked this better. Let's see.
I think page 5.
Am I just missing it? Yes. Okay, page 5, thank you. Number 4, this is where it's discussing the 2 business day transaction reports. Currently, these are the only reports in statute that we have to accept by fax. You're not required to fax them, but you're allowed to. It's the only report that you're allowed to fax into the commission. What happens when you fax it to us is then we have to hand enter all of that data into our system for it to show up electronically. So we would like the option of faxing a 2 business day report to be removed. You would just file it electronically like you file everything else, and that way it would appear instantly on the commission's website. Let's see, I think the next change is over on page 8, the bottom half. This is an issue right now, and it's currently in statute. The commission is required to notify somebody of their late fee by certified mail, which costs me $6.11. If you have a committee, I've got to send it to your committee also. What this would do would be allow the commission to notify you of your late fee in the same manner in which you reported. So for instance, if you're electronically filing with us, we would be allowed to send you a registered email, which the court systems take as having been served. If you file by mail, then we would send you a certified letter. But this would cut down on the expense of the commission has in notifying folks of their late fees, which we statutorily have to do before the late fee is allowed to increase. And this happens in 2 places. This is where it discusses it for the CCDRs, the Campaign Contribution Disclosure Reports. Further on, it's the same language for the personal financial disclosure. The next change is on page 9, and it's in the middle of the page. I'm sorry, excuse me, to the top of page 9. Looks like the 4th line down. There is an issue with what is the final report. The final report is not the same for everybody, and it's very, very involved. But the issue is there are folks that think the 15-day extension period on the final report is their final report at the end of the year. It's not. That's not the intention. So this would just take out, you would still have the same 5 business day grace period on the final report at the end of the year. It just would take out the 15-day, which is very, very confusing as to what your final report is. The next change is in the middle of that page at M. This is putting language back in from the 2009 statute, where basically it's saying that the canceled postmark date is the date that it was considered filed. That is currently how the commission is operating, but it is not in the current statute. It was taken out in 2010. So this would just put that language back in there. Like I said, we're already doing it this way, but this way we could reference that, yes, the postmark date, the cancellation postmark date is the date that we considered something filed when it's mailed. Yes. The letter N under that, this is the 10 days within the dissolution of a campaign or committee having to file your final report and termination statement. This is currently in our rules, but there's nothing in the statute in regards to this. So this was done in contemplation of us still not having rulemaking authority. If we have rulemaking authority, it's not really going to be an issue, but what this does is pull it out of the rules and put it in the statute, that you've got the 10 days after the dissolution of your campaign to file that final report and termination statement. And then on the last page, page 10, it again, this is where it picks up the notification means for the personal financial, and then the the postmark cancellation for the personal financial disclosure.
Mr. Chairman, if you Are you open to questions?
No, I was just going to say, I think you all can see these are very good changes and reasonable, and they're technical basically, but they're ones that the Commission unanimously asked for, and I agreed to present, and hopefully we will get passed and help them be even more efficient.
Any questions from the committee? Representative Higley.
Mr. Chairman, this question is for the Commission, and it's not actually covered in the bill, but is there any way that we can make allowances such that when it's time to file and your computer goes down on the last day of the filing, is there any thing contemplated on making allowances so people will not have that late filing when there is a computer glitch on your end?
It's my understanding that if rulemaking authority is restored to the Commission would be able to consider circumstances such as yours on a case-by-case.
I've never had that, but I'm just saying.
Well, I mean, the one that you're contemplating, we would be able to consider on a case-by-case basis. And obviously, there would have to be some burden of proof on that person to prove, you know, what happened to their computer.
I'm talking about in cases where your site goes down and you cannot get anything to go through. When you have a circumstance like that.
That's been fixed, but yes, I mean, that problem was fixed in December as far as the capacity issue that our site was experiencing, because when the site was designed to handle 1,500 filers. When we picked up all the local filers, we had over 11,000. And so I inherited a very ancient IT system that was not able to always handle the volume during peak filing periods. That's been fixed. We're on virtual servers now as of Christmas. The December filing period where everybody had to file, every candidate, everybody who won, lost, every lobbyist, didn't have a single person that contacted us to say they were not able to get on our website.
Okay, so you don't anticipate that problem in the future?
I don't anticipate that problem, but what I think rulemaking authority would do would allow the Commission to be able to consider on a case-by-case basis if something were to happen to the site or something were to happen with an individual filer that's not contemplated in statute.
Okay.
And that's my intent, and I hope will be the committee and then the House's intent with rulemaking authority, that they can address those.
Additional questions? Representative Flood.
Thank you, Mr. Chairman. I think I know the answer to the question, but I just wanted to clarify. Going back to the first strikeout, I guess the end of page 1 and beginning of page 2, where the term contribution shall encompass has been struck, and you were alluding earlier to the statement that qualifying fees would no longer be expenses. Are you referring to only those qualifying fees if they were paid by someone other than the candidate?
No, sir. The contribution, right now in current statute, it says that the qualifying fee, if it is paid by anyone other than the candidate, is considered a contribution. The Speaker's Bill 143 takes the qualifying fee out as not being counted as a contribution. There's not a problem with that unless you get over to the expenditure side. If you have a contribution, if you have a qualifying fee still counting as an expenditure, then you're never going to get your reports to balance because you're never going to have an offsetting contribution. If all you have is the qualifying fee, you can't have it count as an expenditure if you can't have something offsetted as a contribution. So this would take the qualifying fee out of the definition of contribution and out of the definition of expenditure.
But as I understand it now, if a legislator or if someone qualified for office pays out of their campaign account a qualifying fee, is that an expensable item?
Under current statute, yes.
But going forward, it will not be?
Correct.
No matter where the funds come from?
That's correct.
Even if the candidate provides it out of their own personal accounts?
That's correct, because the problem right now is it's not considered under contribution the way it's worded right now. If the candidate is, let me see, it encompasses transactions wherein a qualifying fee required of the candidate is furnished or paid by anyone other than the candidate is considered a contribution. So
Okay.
you can't have it not be considered a contribution, but have it considered as an expenditure, because nothing's going to balance. There's nothing to offset it if all you're dealing with is a qualifying fee.
But there are numerous expenses that don't have corollary contributions. For example, a website
Yes,
or staff.
Yes, sir.
So
That-
those are expenses that are truly expensible and can be reported, and they don't have a corresponding contribution amount.
That is correct, but this is not envisioning somebody, for instance, at the statewide level or state level, such as yourself, where you're going to have some contributions and expenditures. Folks at the local level that don't raise a penny or accept a penny or spend a penny, accept their qualifying fee, and they pay their qualifying fee themselves. That is the issue here. That it's untenable to have a qualifying fee not count as a contribution, but have it count as an expense, because they're not accepting any contributions and they're not making any expenditures, and it will never balance. In your instance, yes, you're going to have contributions and your qualifying fee would be offset, but I'm not sure how you take care of it for the locals but don't take care of it any higher up.
Mr. Chairman and Ms. LaBerge, if I can interject, I think the question is, are we now disqualifying the payment of qualifying fees from your campaign accounts? Are we no longer going to be allowed to pay your qualifying fees from your campaign account under the reading of this language?
It's not my understanding from our commissioners that they were anticipating that you could not pay the qualifying fee. It just wouldn't count as an expenditure because of, yes, sir.
Yeah. Mr. Lindsay.
So I can pay something out of my campaign account, but I don't have to report it on the next expenditure? That seems like it's going to take everything out of whack, because under theory, you know, the bottom line of what I give you is what, in terms of how much money I still have, should be the amount of money sitting in my bank account. But if I understand what you're saying is that I can still pay for it out of my campaign account, which I should be able to.
Yep.
But it's not going to be a reportable expenditure. Therefore, it's not going to show up on my next campaign report, and therefore the amount of money sitting in my bank account won't be the same amount of money I'm reporting on my next expenditure. Or am I just totally lost?
Well, in speaking to, and this is mostly the locals that we were trying to help here, because most of them, because they don't have any contributions, they pay for their qualifying fee out of their own pocket. Yes, right now, under current statute, that would be considered an in-kind contribution, and then they would have the in-kind expenditure of it. I see what you're saying. We're between a rock and a hard place as to how to completely fix this. So I will leave it up to the will of the committee to massage this further.
Representative Willard.
Well, tell me this, what is the ill that we're trying to solve here? Because I came in halfway in the movie. What is, I mean, I got contributions in my account from various sources, and come qualifying time, I got a check written to pay my qualifying fee. That's all understood and permitted under the current law. What is the ill that we're saying exists that needs to be done away with?
The issue is with House Bill 143 that contemplates with the local filings being sent back to the locals, and that if a local does not raise or spend over $2,500, they would not have to file any reports. They would file the affidavit. That bill states that a qualifying fee would not be considered, not be counted in the $2,500. So it's not counting it as a contribution. But if you're not going to count it as a contribution, then you can't have it still in the statute where a qualifying fee would be an expense.
But we're also saying, as I read this, that will no further be permitted, once this were enacted, for us to pay a qualifying fee out of our campaign account.
I see what you're saying, sir.
Period. I mean, because now it's expressly permissive. If you remove it, if I'm a judge saying, well, you legislators remove that tells me that the intent was not to be able to do it.
Yes, sir.
So I'll be committing a crime.
I understand what you're saying, and I think that was my response to Chairman Lindsay, that we're kind of between a rock and a hard place trying to get this straightened out, and so I'm sure the committee will be able to
Well,
massage
I don't think
this
you'll
much
have a
better.
qualifying fee. The amounts, most of those local offices are $300, $200, $100, whatever dollars. If they still haven't met a threshold, is there a need for them to make a report? If they, let's take the example, I'm going to run for council, I'm going to pay a $200 qualifying fee. I pay it out of my pocket as a personal payment to run for that office. Now, that's all I've had. I just get on the telephone and call everybody, so I don't get any money in, don't pay any money out. I'm under the threshold. Is there now created a problem?
Not with that, sir, but I'm not sure that where the $2,500 threshold is going to hit some of these folks with these qualifying fees, because there are local qualifying fees that are over $2,500.
Maybe. But we said in the legislation 243, it's not going to be considered a contribution.
Correct.
Therefore, it can't be expense either.
Correct.
143, excuse me. Okay.
Leader O'Neill.
A couple of questions. Thanks very much. I wanted to follow up first on what Representative Hughley was talking about earlier, and in connection with the change on page 5 about facsimile. I understand, and I'm very happy and enthused that we don't have the problem of getting in the system anymore. But when you take out facsimiles, that was at least a way that if you couldn't get in the system electronically, you could prove documentarily later that you did timely file, thus not get fined and politically eviscerated because of that. Even with rulemaking, I don't know how you're going to establish how you're going to prove it. I'm not necessarily for keeping facsimiles, but unless your fax machine was broken down, we got a timed receipt when we sent that in. When your system didn't work, we had no way to prove we tried to make the report or not.
Right. I understand what you're saying, but this
can we get that in rulemaking? Can we get something fail-safe that if we act in good faith, that we won't be penalized just because of whatever may happen if the system fails again? That's a question, not an argument. Is there some way we can do that?
I'll try to answer that question. Let me back up and just say that the 2 business day report is the only report you guys at the state and statewide level can fax. Everything else has to be filed electronically, everything. So this was just bringing the 2 business day into alignment with all the other reports you file. I do see what you're saying about the fax having a date stamp on it. As far as rulemaking authority contemplating some sort of fail-safe measure that if you can prove, and I'm not sure how, I mean, I would think the burden would be on the filer to prove that they attempted to file and were not able to because of something with our system. I would not really be able to speak to that because my commissioners have not discussed that with me, and I'm not sure what their thinking on it is, and I hate to speak for them in their absence. But rulemaking authority would, my understanding, would allow us to look on a case-by-case basis. And I've had people send us screenshots of things. 9 times out of 10, it wasn't our system. It was the resolution on their screen. Or I mean, I've got a pretty crackerjack IT department right now, and they've been able to get a lot of these issues straightened out and been able to help filers that claimed that there was an issue with our system, and when we really dig into it, we find out it really wasn't an issue with our system. That being said, there will still be some, I mean, it's not fail-safe. There may be something that goes wrong. And yes, if we could prove some form or fashion that it was our system, I think rulemaking authority would allow us to make a case-by-case decision.
Well, I would appreciate any guidance on how we could verify the attempt was made to where there's a standard for that, so that whether or not a screenshot is the standard that your commissioners. I don't want it to be decided on a case-by-case basis if we have people acting in good faith. And the reason it came up with the 2 days, that's probably the most time critical. There's no forgiveness after 2 days. There's a penalty, and you've acted evilly in the eyes of the public. And regardless of how you explain it later, that's always going to be on the back page of the paper, not the front page. And so I would appreciate some help on that. And I wanted one other question, if I might. Following up on the page 2 thing, and I understand the dilemma. What we're really trying to say, and I think Representative Chairman Willard articulated it well, was the expenditure we're talking about lining out here is really just the one based on the formula to reach the $2,500 threshold. it still is an expenditure. It still is a permitted expenditure under ethics law and so forth. And I think we're unnecessarily confusing it. Maybe the change here for the committee to consider might be solely for the purpose of calculation of reporting threshold, and that's it as far as this line out is concerned. I'm not a good enough lawyer to craft that entirely, but isn't that what is? My question is that what we're trying to get at there?
Yes, sir.
Madam Chair, this is Mr. Burge said, this has been a very difficult issue, and now the facsimile issue that's been raised. I think what I would probably like to do is get with Holly, go back to the Commission, Legislative Council, and instead of just trying to craft it this afternoon, let me try to redo this and bring it back.
Certainly.
Because, as you know, my motto, do it right the first time. So.
Absolutely. Are there any other questions from the committee?
Yes. Thanks.
Thank you, Mr. Chairman.
Okay, thank you.
I know. It was a heady experience. Thank you for my first and last experience as chairman. For now.
Chairing ethics, Madam Leader, as you now know, chairing ethics is a negative perk, so at best. Thank you all, because these are some good questions that I want to sit with the Commission and work closely with them, and also with Legislative Council to make sure we get this right. Okay, next, Chairman Hill, recognized. Where's
Okay, thank you very much, Mr. Chairman and committee. Today, I'm bringing back, I would say, a resolution and its accompanying bill that I had presented several years ago, because it was then brought to my attention that the provision we currently have in our state constitution to prevent tax defaulters from being eligible to hold public office really could be strengthened, and that we should also have a good mechanism to obtain the release of otherwise confidential information just for the purpose of enforcement of this provision. In fact, if I may, I'd like to read an email that I received this afternoon from an attorney actually in Cherokee County that experienced that this year, where he said he wanted to applaud my effort for filing this resolution regarding tax defaulters by public officials. The language of the Constitution that you're proposing to amend is in serious need of revision, since it is virtually meaningless and unenforceable as currently written. Thank you for taking this on, and let me know anything I can do. I certainly attest, given my recent effort to enforce this provision, that it is without teeth as it stands now, and that was because he could not obtain the necessary information in his process to prove his case. So the resolution, House Resolution 298, simply states, and if you would follow, I presume you all have a copy of it there, that on line 8, that we further define that this is for state and local offices. And on line 24 through 26, we're identifying those who have simply just not filed their tax returns. And on lines 27 through 30, we're identifying those that have failed to make payments through a final proceeding that has been approved by the appropriate taxing authority. And then lines 31 through 38 create the provision that we discussed that allows a person that's qualifying for the election or holding an elected office for them to sign a release to release the confidential tax information to the Commission to ascertain compliance. And then lines 39 through 43 just clarify that the office of a person that is found in violation by the Commission shall be declared vacant, and the vacancy would be filled in the normal manner for that office. It really is that simple, and I think keeping simple is best, because we're not trying to overcomplicate this, but just to make it a constitutional amendment. And of course, it would need to be ratified next November 2014 at a statewide general election, and it would take effect the following January. And in order for that to be enforced, I have House Bill 333 that is accompanying it, and this bill is designed to do one thing and one thing only, and that's to allow the Georgia Government Campaign and Finance Commission or its successor to investigate following a written complaint of this previous article, and it allows the release just to the commission of otherwise confidential taxpayer information that would be needed to investigate and confirm the complaint. And of course, that bill would become effective on January 1 of 2015, provided that the resolution, House Resolution 298, is ratified by the voters in the previous November's general election. And of course, if not ratified, then this bill would stand repealed. So with that, Mr. Chairman, I'm open to questions.
Mr. Leader?
Presentation, I'm referring, and I know I signed this bill, so I realize I'm questioning my own bill, embarrassingly so, but I just saw something I haven't seen before. I'm looking at line 27, and it says, has failed to pay or make arrangements for payment of any federal, state, or that has been finally determined through an administrative or judicial proceeding. If I get an assessment, for instance, or you get an assessment from the Department of Revenue, that's an administrative proceeding, I think. And it may be a math error from 5 years ago. Is there a reasonable time contemplated from when you're notified that you have an obligation that you otherwise didn't think in good faith you had, where your return had been filed and taxes had been paid for 3 or 4 years, and then all of a sudden there's some mathematical nominal error discovered? And the reason I raise it now and before, I mean, that just happened to me a week ago. I had a 2008 assessment from Revenue for like $16. I had no idea about, obviously, and I just instantly paid it. But I guess technically under this language, I would have to be unseated and somebody fill my seat, or am I wrong about that? I mean,
I believe, sir, that you would be wrong, because you know, that would give you an opportunity to file an appeal or a correction. And anybody that has, if I show, let me go back and make sure.
This says pay or make arrangements. But that doesn't contemplate filing an appeal. That's what I guess my question is. For even 1 nanosecond from when I get that notice that I owe it, I'm in default as I see this language. Unless I'm wrong, tell me, and I have been many times.
I think on the page prior to that, where it gives you an opportunity to file an amended return or other filing in a timely manner. So here, if you've discovered a mistake, you could make another filing to correct that error. And I believe that language would cover that. If not, I would certainly, we've got a panel of attorneys in front of me that are certainly much more capable than I, and I would certainly be open to any language that would cover that situation.
Who's next?
Well, and further, and I'll stop, if there's a bona fide dispute, and I used to work in that field, and there truly are many bona fide disputes on assessments, since that is otherwise defined as an administrative proceeding, you're technically afoul of this language, so to speak, until arrangements are made. And if arrangements include filing an appeal or a protest, then maybe that would work too. I certainly don't want to preclude anybody elected with the same rights every taxpayer has to appeal.
Absolutely, and that's certainly not the intention of this, of course. And if there's some clarifying language that we could put in here, I would certainly be open to that.
Madam Leader.
Thank you. Following along with the leader's concerns, Chairman Hill, I appreciate the intent, and when this was offered before, and I appreciate you bringing it to my attention earlier this session, the fundamental concern I have is that we're intermingling multiple types of taxes in this document, and the there is no uniformity to how these things are adjudicated. I was a tax attorney, and I once dealt with a 3-year. They filed, but there was a dispute, and you couldn't get to an arrangement for almost 3 years because you had multiple tax jurisdictions that were in disagreement about the nature of who was actually responsible for assessing the tax. I think for multiple members of this body, especially if you live in a certain county, you've been hit with liens that you never had notice of. And so the challenge is, because of the scope of what we're addressing and the complexity of the situation, I think to the leader's point, I find it very difficult to create language that would not be the same size as the existing tax code in order to solve for what you're attempting to solve for. And I guess my fundamental question is the concern about those who have been in final default, or is it anyone who is in the process? Because if we're trying to get to final default, there is a space when that happens, but what this contemplates are lots of interstitial moments which are, have very different resolutions. And so I guess I'm trying to make sure I understand what we want to actually accomplish.
No,
here.
the intent is in final default. Absolutely, is when somebody is, continued, gone through all proceedings, final adjudication has been to pay it, and they just don't pay it. And final, at that point is what we're looking at. Or somebody that just does not file or refuse to file, and there are those people that refuse to file taxes.
Okay.
So it's certainly not to trip somebody up on a minor error or something that's overlooked. We would like to give them that opportunity to correct that.
Thank you, Mr. Chairman. Chairman Hill, I'm new to this committee and just want to make sure I understand a couple of terms. So on line 24, where a person has failed to timely file any individual tax returns required by federal, state, or law, what's the look-back period? What's the look-back period? So the current year,
there is no time. It's
years,
not a year. It's ever. If you haven't filed them,
ever in life.
That would be correct.
Okay, that's one clarification. Now, does this consider if someone is removed from office, would there be a remedy or an opportunity for them to be able to? So, if they were removed from office because they a declaration that they failed to pay or failed to file a timely amendment, does that mean that they would no longer ever be eligible to run for office again?
Once they have complied, once they have corrected that default of filing their taxes or whatever the problem would be, there's nothing in this that would prevent them from running again. That would remove that obstacle, because then they would be in compliance.
Okay. All right. Thank you.
Tell me, could Chairman Hill, the language we have currently, which is the part struck through, was added about 4 or 5 years ago, wasn't it? As I remember, I know since I've served, this was language added as a constitutional amendment where it says who is a defaulter for any federal, state, county. This is lines 12 through 17. Was that about 4 or 5 years ago?
No, it was about 4 or 5 years ago that I attempted to, or I did present virtually the same resolution. This language that was in there, I don't know when it was added. It would have been prior to that at some point.
Okay.
I'm not sure.
My mistake. Well, what I'm concerned about, I'm fearful of what I call gotchas in the situation that is outlined with your proposal because of administrative mistakes that could be made. And frankly, the holding of an office, believe it or not, is a property right by law, looked at. And I'm worried about saying we're taking away what is this right, a property right, without some oversight by court saying, a court of competent jurisdiction providing that due process to say you have failed to do what the Constitution said you're obligated to do, and therefore by due process the court makes a decision to remove you from office, take away that, quote, property right that that party may have. So And I was thinking to myself, a couple of years back, you pay taxes on a quarterly basis, I do, being self-employed, and they applied either by my mistake or State Department of Revenue's mistake, the monies to a different year, and all of a sudden one day I'm getting in the mail a tax execution from the state office after we filed the tax return, because and without any other prior notice. And I say, well, wait a minute, could you write me a letter about it or something? So I guess that would be the administrative determination that I think your bill, and as this leader spoke of, that is administrative determination by issuing an execution. I'm in default and failed to pay. It's a serious move, what we're talking about there. I'm not saying people who are not paying the taxes have a right to continue to hold office. I'm sure back when this language was added to the Constitution, there was thought about that from the standpoint of, well, what would we do about due process to answer that problem? And I don't know if the bill, as you're suggesting, rises to that needed level of due process. That's my concern.
Well, what we're actually trying to do is to clarify it. You know, we already have basically that existing wording in there that we can remove somebody and then make them ineligible to hold office. And what we're trying to do is actually clarify that and make it a little easier to make that decision by allowing the introduction of otherwise confidential tax information. So, you know, perhaps the wording needs to be just to clarify that there has been the final notice on a taxing question, and I'm going to have to again refer back to Legislative Counsel that helped draw this up and see if we can get that wording to meet your concerns. Because again, the wording in the Constitution already addresses this conceptually. Mm-hmm. Again, it just leaves a lot of loopholes. It cannot be enforced.
Well, it's probably it's a more extensive process to enforce it, and I don't know if that's an evil or not. I guess the question is, just beg the question. Thank you, Mr. Chairman.
Thank you, sir.
Chairman Ramsey.
Thank you, Mr. Chairman. I guess just very much along the same lines, I think right now, current law, the trigger to ineligibility to hold office is final adjudication by a court of competent jurisdiction. And what your resolution here does is it reading it literally, 24 to 26, for instance, failure to timely file. I mean, I could file a return, get lost in the mail, and there's no provisions for notice or cure, or there's no time period in which I can fix it. It really, reading it literally, I know that's not your intent, reading it literally, the Georgia Government Transparency and Campaign Finance Commission would be within their, I think the way I read this, within their authority to deem you ineligible to hold office without you ever getting an opportunity to cure the issue that's been raised with respect to your failure to timely file. So would you be willing to, I know it's certainly not something we need to do on the fly here, but consider some kind of notice, cure period, or put some kind of automatic stay in place where the Transparency and Campaign Finance Commission, if you're disputing that you've committed a violation until such time as that, while that disputes, you're actively pursuing resolution to whatever the alleged violation is.
Oh, absolutely. You know, again, the intent is not to entrap anybody here, but
right, because I think the comfort before it comes in that the trigger to being removed from office was a final adjudication by a court of competent jurisdiction. So that means that there's been a process that the taxpayer, has been engaged in to reach that point, and I think that's what we need to make sure those protections are in place in the context of what you're trying to do. So,
thank you,
Absolutely.
Madam Leader.
Thank you. I have two more points just as you continue to work through it. Going back to the question of curing, there are certain tax filings that after a certain period you have no ability to cure because, for example, you can't go back and file a federal tax return 10 years too late. there's a moment where they won't accept it because they've closed those files. They're not going to reopen. So there are opportunities where there's a permanent inability to cure, which would remove the remedy that you're trying to make available. So I would just think about building that in. And then looking at actually House Bill 333, line 14, the issue of the written complaint, right now under Georgia law, anyone can complain about you without any offer of proof. So you can have a complaint filed against you simply because somebody doesn't like you that day. And the Supreme Court has decided that in Georgia, the burden of proof is then on the office holder or the candidate to disprove the negative, not to prove that there was any basis. And my concern would be that we're creating a floodgate of work for the commission, because they can receive this, they would have to investigate every single complaint, because we don't set any standards for any offer of proof. And because you put in place federal, state, and local taxes, you're talking about getting the federal government to agree to give you these records, because shockingly, not every taxpayer keeps the records they're supposed to keep for the requisite number of years. You're asking county commissions who have tax assessors who may or may not timely provide lien information. And if someone fails to provide adequate information simply because they don't know what they're trying to prove, I think we're creating a very, very complicated system here that we really need to think through, because you've got a lot of folks who are going to be sending information, unless we're going to hire a lot of tax attorneys to be at the commission to evaluate the legitimacy of these claims.
Excellent.
Thank you.
Chairman Hill, as you know, this committee is charged with oversight on House members who have not paid state taxes. Originally, we were dealing with state and federal, but the IRS told me in no uncertain terms it was none of my business, and that information would not be provided. So we are only provided from the Commissioner, Department of Revenue, information on Georgia taxes.
That's correct.
So I wanted you to be aware of that. That's okay. Anyone else? Well, it sounds like we're all going to be spending some time at Legislative Council the next few days, Jeff.
Okay. Well, thank you very much, Mr. Chairman. And that's what the committee process is for, and I certainly appreciate the input, and I'll see if I can go back and perfect this.
Well, we'll try it. And is there anything else to come before the committee? Ladies and gentlemen, thank you so much. And as I said, Holly and I will be back with after meeting with the commissioners and Legislative Council to make sure that there's no confusion and somehow we can get between or away from that rock and hard place. We're just trying to help local, as you know, trying to help all the local officials who have complained so strongly about the filing and so forth. Thank you.